Hey, you guys, what's going on? I probably won't be on here very long, but I did say that I was going to come back and hopefully YouTube sent out notifications. But what I wanted to talk about is something that I have read upon and I'm continuing to do my reading and my research. And I came across some interesting information when it comes to CPS. And so, with this procedure, well, not procedure, but with this process here, you absolutely have to have a lawyer, but it's nothing wrong with you bringing this information to your lawyer's attention. And I heard this from a CPS lawyer. I can't remember the name, but I probably will add it in the description box below. But the CPS lawyer went on to say, how do you get a chance to cross examine the social worker for CPS? Okay, so many people don't know that you can actually cross examine your CPS social worker, especially if you guys are going back and forth to court. Okay, and I took down a couple of notes because it would help me to stay on track because sometimes I get thrown off track. One of the things that you want to do is to bring all these various things to your lawyer's attention. You can't do it yourself because you're not a lawyer. And when you are getting a lawyer, my advice to you, which I'm not a legal advisor, I'm not anything of that nature. I'm just a person that has been doing research and trying to get information, okay? So my advice is to make sure that if you get a lawyer, make sure that that lawyer has a lot of knowledge about CPS, because if the courts find out that the lawyer has no knowledge of CPS, then they can eat your lawyer alive, and then you'll be angry with your lawyer thinking that your lawyer didn't do his or her job when in fact they did what they could do. So you have to indeed find yourself someone that is how do I say, educated with CPS. They know a lot of the laws, the rules, the codes, and all the procedures, all that stuff. They know what the do's and don'ts. So don't just go get you a regular old lawyer and think that that lawyer is going to say, okay, we're going to get your kids back. You're going to be fooling yourself, and you're going to be setting that lawyer up for failure. I believe I told you a story in another video where this young lady was trying to beat the system by being slick. She had a court order not to go and visit her kids, but yet and still she went off and she sought the information from a lawyer without informing the lawyer. Well, she gave the lawyer the paperwork after the fact, after he gave her the information that she absolutely can go and see her children and have her children with her. But by the time the lawyer read through it, he found out that she had pulled a slick one on him. So they appeared in court on Zoom, of course, because a lot of procedures are still not being done, within the actual court system because we're still getting over the pandemic. So the lawyer came forward, and the judge told the lawyer, you could have gotten her in a whole lot of trouble by telling her to defy my orders. And he said, well, when she explained it to me in a different manner. And so once I got an opportunity to read the paperwork, then I understood that it was an order, and I have no legal training in the area of CPS. So the judge could have fined the lawyer by this girl being slick. But it's a good thing that the lawyer, excuse me, that the judge understood that this lady was being manipulative and put this man in a very bad situation. So the judge gave this lawyer the opportunity. If you want to stay, you can stay and kind of get some information. But he was so embarrassed and upset. that he did not want to stay. So he said, no, thank you. I definitely will bow myself out. So, with that being said, make sure that you get a lawyer that understands CPS and all the DPSS and all those different terms and all the terminology that is used in that type of court situation. Because once you go into a consecutive hearing or a trial, you definitely need to have all your information together. You need to have all your facts straight. You need to not be misleading or anything of that nature. Also, that you make sure that you get a lawyer that is not radical. If you heard that noise in the background, forgive me. Make sure that your lawyer is not a radical lawyer, that he's not a smart aleck, that he's not disrespectful, because this also can work against you in court. So, with that being said, during a consecutive hearing, the most important part, okay, in the most important part of a contested hearing or a trial is to cross examine the CPS worker. And so, what I found out in that, you can question, but first you have to do something. Number one, you and your attorney must make sure you request that the CPS worker is present at the trial. You must request that the police officer is at the trial. You must request that, if you can, that the foster parents are at trial, or your family member who has your children are at trial. Anybody that has something to do with your child and the trial, you must make sure that they are present at that time so that you can do your cross examination. Now, this is what happens at the trial, and I'm going to give you an example. So, you go into the court with your lawyer, and the CPS worker or whoever it was that came, that worked on your case, you say, I'd like to call I would like to call Team Angel. Let me use Team Angel, okay? And Air Force One, because they are the actual people that came against you in the case. And I would like to call, they ask you, do you want, I'm getting so messed up. Excuse me, you guys. And you say, they say, okay, I messed up. I'm sorry. Forgive me for that. I messed up. They say, because it's hard to read my own writing. It says, Team Angel, would you like to call your first witness? And then Team Angel says, thank you. Now I'm on track. Team Angel says, yes, I would like to call Air Force 5, the social worker that worked on this case. And Your Honor, and then the county council district attorney for Air Force 5, which is the social worker, will say, um, Team Angel didn't subpoena or ask that Air Force 5 be present at the trial during these hearings. So how are you going to cross-examine Air Force 5 if you never gave him a subpoena to be present here at the trial? So that would be your first mistake, not doing a subpoena, okay? So you absolutely have to do a subpoena in order to get the people that you want to be at the trial and or the hearing. And number one, it says make sure you subpoena your social worker, make sure you subpoena the social worker's lawyer, and make sure that the police officer has been subpoenaed. Anybody, the family that has your kids, whether it be a foster parent, if you can get the address, or whether it be your family member, okay? But I know for sure out here in California, according to the information that I was able to get, California has a code of civil procedure, and it should be in section 1987, and they abbreviated CCP 1987, and you can definitely Google that form. And then they said if you want a party to be subpoenaed, you can use this form, okay? But you should actually send this form out probably 15 to 20 days prior to the trial, okay? And for the social worker and or the police officer, maybe you should do 20 days if you're going to do it by mail, all right? And there's something called a notice to pursuant subpoena. So I believe you can use that as well. Okay, so what you want to do is you want to list the social worker, you want to list the children, you want to list the foster parents, you want to list your family member if the family member has your child, you want to subpoena or list the police officer and the lawyers, and you can send it to them and have them all subpoenaed. So when you go to court, when you call your witness, then you won't be sitting here scrambling like, oh my God, I don't have a witness. Okay. So the second thing that was written down was when you call a social worker, please make sure, like I said, you are not displaying any disrespectful behavior. Make sure that your lawyer is being very professional and polite at all times, even if you guys hate that person. Okay, even if you can't stand Air Force 5 for nothing in the world, be absolutely polite at all times, because this can also go against you. If you are disrespectful and rude to this CPS worker, their lawyer, or anybody else that is not in your favor, this will probably upset the judge very much so. And then it's going to mess with your case, okay? So when the CPS worker is on the stand, always greet them good morning, good afternoon, good evening, okay, ma'am or sir. So make sure, like I said, don't come in there like a gangbuster and you want to be all radical just because your lawyer might have won multiple cases. You can't treat everybody the same. So, with that being said, please, that is number one. Please do not slouch and be like, oh man, this heifer, oh, this fool. Don't do none of that. Come in there with the utmost respect, because no matter what you think, they are looking at you still. They're paying attention to your reactions. They're paying attention to your body language. They're paying attention to your response. And don't think that once you get up there and they start questioning, they won't take a break and say, you see how rude and disrespectful, you see how she was acting? That's probably why they don't want the kids back with her, because of this attitude right here. Look at how simple-minded she's acting. She act like she just don't care, like she just real whatever. So don't put yourself in that situation. I don't care if you have to rehearse and keep reminding yourself to smile, to be polite, or anything. Don't put yourself in a bad situation, okay? Um, hold on a second. And then it says to get out all the social workers' major things. This is what your lawyer is going to do. Welcome to the chat. Please let me know who you are so that I can greet you appropriately. So get out all the social workers' major things. This is for your lawyer, and you can talk to your lawyer about this whole situation. So, excuse me. Number one, you can say, ma'am or sir, isn't it true you are not recommending that the child be returned to my client's home today? This is what your lawyer is asking. That is it true or is it not true? Okay, that the child will not be recommended to go back home with you. This is what your lawyer is asking. And so once that person answers the question, then if the lawyer is smart, you can have your lawyer have them hand them a legal pad and write. And then you can say, when the lawyer hands them the pad, say, tell me all the reasons why you do not recommend that the child be returned back home to the parent. Okay. So then he went on to say, you might, like they said, you might want to hand them a pass so they can write down their reasons. And they may have 100 or more reasons why they feel you should not be able to take your child back home. Okay. So once they sat down and they wrote all this information as to why they feel like you should not have your child returned back to you, what your lawyer should do next is take that one piece of paper that person wrote all their reasons down as to why they feel that your child should not be returned back home to you. They should take that piece of paper, tear it off, and use it in your cross examination by filing it in the court with the court's clerk as examination. Okay. Or exhibit or something, examination. I can't remember the exact word, so please forgive me. Like I said, I was writing kind of fast. Okay, now after you have filed it with the court's clerk, you then take that same piece of paper and you use it in your cross examination. And this is for the lawyer. When I say you, I mean the lawyer. Okay. So after he or she has given all their reasons, make sure you take notes on each question that you go down. All right. So if they say they don't feel like your child should be returned to you because they think that you're not a good person, then your lawyer should be taking notes on their response by asking them to explain. As they're explaining, you take those, you and your lawyer both write the notes down. Next, you ask them after that, next, as it is that all the reasons why you have that you have today to say why you don't feel that the child should be returned, to their parents. And if they, sometimes the social worker will say, I have more reasons. Okay. Then the lawyer will say, okay, then tell me why you have more reasons. What are they? Explain them to me. What are the reasons why? And so they get the chance to explain their reasons why. Okay. And then it says, hopefully your lawyer will frame it to a 3 to 5 reasons. Like give 3 to 5 main reasons instead of doing maybe 100 different reasons. Okay. And they say, go back to each reason and do a drill down. And a drill down is drilling it down to maybe 5 major questions, is what I'm thinking. Go into the specifics of why they said what they said. Okay. And then it was stated that if the social worker says, I don't think mom can keep the child safe, your lawyer should then say, okay, sir, ma'am, why don't you think the mother can keep the child safe? Now, all this time that this person is talking, you're taking notes. Okay. All right. All right. So then mention and discuss this with your lawyer. That's what I was telling you. Mention and discuss all this information with your lawyer that I'm telling you about. And you can find this lawyer on kabc.com. I don't remember his name, but you can find him on kabc.com. If a social worker tells you that they will take your child or your kids if you don't do a drug test, you must know that the CPS cannot do that. The tests that the CPS uses are not reliable. They should not tell you that you have to take a drug test. And if your lawyer goes to court with you before the trial and the judge tells you in front of your lawyer that you have to take a drug test, your lawyer should stand up to them and tell them that it's not constitutional that you have to take a drug test. Okay, it's not, he does not, or she does not have that jurisdiction over you to force you to take a drug test before the trial has begun. Now, once the trial has begun, if they request a drug test, then that's something different. But before the trial, they have no jurisdiction. The CPS does not have jurisdiction to force you to take a drug test, because a lot of those tests come out inconclusive. A lot of them come out with different things wrong with them. They are not allowed to tell you that you have to take a hair follicle sample. That is against your constitutional rights as well. They cannot make you take a nail drug test. That is also against your constitutional rights before the trial has begun. But as the trial begins, your lawyer should be able to determine, like I said, once you get a CPS lawyer, they will know the ins and outs of what what the judge can and cannot do. Okay. They said it is unconstitutional. If the judge orders a drug test, make your lawyer deny a drug test. Remember that. I'm saying it again, because they don't have a right to force you to take a drug test, especially if it was not a call about drugs. If it was not a call about you being on any type of controlled substance, they have no constitutional rights. And the lawyer can tell the judge politely, you have no right and you have no jurisdiction to make my client take a hair follicle test, drug test, or any other test that has to do with drugs, because my client absolutely has no, this was not a case about drugs. Now, the gentleman went on to say that he had a case where there was a grandmother that had the children, and the CPS worker did not want the children with the grandmother. Okay. And so the lawyer was like, well, why don't you want the kids with the grandmother? And the CPS worker, for whatever reason, just did not like the grandmother. The grandmother never did anything to her. She complied with all the rules. And the CPS worker burst out and incriminated herself and said, I don't want her with them because she's a Jamaican. And we all know that Jamaicans are drug dealers. And he said that the judge was blown away when the CPS worker made that statement and that comment, because that was the utmost prejudice and misleading thing that social worker has ever said. And I'm telling you, if you get the right social worker, they will definitely display their disdain for you. And then your lawyer can put it on based on what her personal opinion of you is. And there's no room for her personal opinion. He's there to do a job. Nobody asked you for your opinion, how you feel about me. And you didn't even know this lady to even make that kind of a statement. First and foremost, all Jamaicans are not drug dealers. All black people are not gangbangers. All white people are not what they say they are. All Asian people are not what they say they are. All Hispanic Latinos, I'm going to say, because Hispanic, that's disrespectful to me. All Latino people, Latin descent people are not what they say. All nationalities of people are not what you think they are. Unless you are a personal friend of theirs, then you have a right to say something. But if you don't know that person on a personal level, you have no right to judge their culture if you're not a part of that culture. So before we start judging people and talking about people's culture, just because you got a couple of bad apples out of a basket of apples, that does not mean that the whole basket of apples is spoiled. You just, discard the spoiled ones. And then once you discard the spoiled ones, then you'll see that the rest of the basket is flourishing. So you can't do that. Hi, Team Angel. How you doing? I'm talking about ways that you can people don't know that they can actually cross-examine their CPS worker when they go to court, but you have to subpoena them. And hold on, let me tell you the name of the form again. I put my notes away because I was just talking. So What is the name of the form? The name of the form is called CCP 1987. And what I'm going to do right now is I'm going to go ahead and Google it. Can you let people know that I'm on if it's possible? Now I feel like I'm catching a little cold because yesterday, this weekend, it was scorching hot. Now all of a sudden it is ice cold outside. So the weather change is definitely something. One minute you sweating and the next minute you freezing. So that to me is bizarre weather. I don't know what the heck is going on. Um, so hopefully it's just messing with my throat. I don't know why it has to be like this out here. I'm telling you, California is something crazy. This weather out here is something else. Like for real, for real. Hold on, I'm trying to blow it up some so it could be seen on the screen. Hold on, let me try to share this. Oh, come on, share the screen. Share the screen, girl. Let me see. So, okay, there it goes right there. So this is the actual form. It's called the California Code of Civil Procedure, CCP 1987, and it's current as of January the 1st, 2019. And so this is one of the forms that the lawyer was talking about. He said that you can actually use this form to subpoena the social worker. So I'm looking at this and I'm trying to see where this form, if it's a form, this is just information right here. Okay, in the case of the production of a party to the record of any civil action or proceeding, or of a person for whom immediate benefit and action or proceeding is prosecuted or defend, or of any, oh my God, who is an officer, director, or managing agent of any such party or person, the service of a subpoena upon any which witness is not required if written notice requesting the witness to attend before a court or at a trial of a issue therein. Why they gotta write all these crazy words within the time and place thereof is served upon the attorney of that party or person. The notice shall be served at least 10 days before the time required for attendance unless the court prescribes a shorter time. If entitled thereto, the witness upon demand shall be paid witness, shall pay be paid witness fees and mileage before being required to testify. The giving of the notice shall have the same effect as service of a subpoena on the witness, and the party shall have those rights, and the court may make those orders, including the imposition of sanctions, as in the case of a subpoena for attendance before the courts. So they write their wording where you like it's almost like that. Thou was thee, as though of they, if all that crazy stuff. Give me one hot second. Yes, excuse me for a minute. I had to take care of something real quick. Oh, be careful. So, this is what I wanted to talk about. I didn't want to hold nobody long. And I know that a lot of people are probably busy, looking at the videos. I did my little spill on Will Smith, which I totally, wish I hadn't have done, but I did it, so that's what I wanted to talk about, Team Angel. I just wanted to bring that information about the subpoena real quick. Okay. So I'm going to go ahead and scroll up so people can see it so that I can, okay. Ugh. So this is what it's called. It's called the California Code of Civil Procedure, CCP 1987. And we will get more into that on a later date. I just wanted to bring that to you really quick. So, with that being said, have a blessed evening, and I will talk to you guys in the next video. And don't forget to hit that like button, that post notification bell, and don't forget to subscribe to the channel, you guys. And don't forget to share this video. And I'll talk to you guys later. Bye.